not necessary, or it is deemed to have been granted. According to me, even that word deemed should not be there at all. It's not necessary. 19 doesn't apply, notwithstanding anything contained in any other law. Section 19 shall not apply to the offences under the Prevention of Act in the state of Goa. You can make a law. Of course, it should be reserved for the President's assent. Now, Karnataka has done that, but not in regard to 19, but in regard to other offences affecting 197 of the Criminal Procedure Code, and has obtained an assent from the President in 84, 85. But this assent should be obtained before the enactment is placed before the legislature. So if that is done, I think this another major problem of obtaining sanction also would go, and that is a necessary thing which is not there either of the other thing. On the contrary, it says they shall take necessary permission from the competent authority. Then another deficiency which I found was in section 22 of the Goa Lokayukta Act is the same in this thing, that is, an elected representative shall before 30th of June file a statement of his assets and liabilities for every year and for succeeding year. Mr. Kalam, please note one thing there. The word used is before 30th of June. That's a very, very ambiguous word. On or before is the normal language used when a date is fixed. On or before. Because a lot of questions arising. They come on 30th and they give it. And a person like me says, sorry, it says before 30th. That means 29th, which is not mentioned in that. And rest of it is the same as Karnataka, this thing that you send a report and you publish their name in 2 newspapers. This act doesn't say that the copy should be sent to the governor. In our this thing, a copy is required to be sent to the governor along with the list of persons who have defaulted. And a notice of that will have to be given to the defaulting member. And our act goes one step further and says, 60 days after that, if he still doesn't file it, that is on the 31st of August, you can publish his name in 2 prominent newspapers. This is no punishment. On the man, thing they think it's a compliment. His name coming in the newspaper is always taken as a compliment. But then there is a provision, section 176 under the Indian Penal Code. I have used that section in Karnataka. That law applies in Karnataka also. The section 176 says, any person who is required under law to furnish any information to a public servant fails to do so in the time and the manner prescribed therein, he shall commit an offence under this section, and which is punishable with 2 months imprisonment. 2 months is 2 months with the imprisonment. Simple imprisonment. Now, I am a public servant as a Lokayukta, not now. The law, that's the state law, the Lokayukta Act, requires an elected representative to give some information to the Lokayukta before 30th, and if he fails to do so, he commits a temporary misconduct. But after 60 days, he still doesn't do it. Then he has failed to furnish that information as required and prescribed in the Act of Lokayukta. So it's an offence under 176. So we have filed it, the court has entertained, taken cognizance of it, and the matter is being tried. Similarly, there is another interesting, 177. There is no provision made in either Karnataka Act or in your proposals, or 2003 Act. But 177 says, such a person who is required to furnish that information under section 176 of the Indian Penal Code deliberately gives incorrect or false information, he shall be liable for his punishment of 6 months. Otherwise, what happens? He'll give whatever he wants to give. He will include what is not his, he'll exclude what is really his, but there is nothing except his name appearing in the newspaper, correctness of which cannot be gone into by the Lokayukta. We have now been holding every return that is filed either by the MLA or the MLC. A separate department is opened to compare it with the previous years, and if we find any discrepancy, we have issued notice under 177. We have filed charge sheets also under 177, and the courts have taken cognizance of that. Therefore, that section should be included. It's not there in Karnataka also, but a proactive Lokayukta may do it. But it's much better to put it, notwithstanding anything contained in any other act, including this, right? The offences provided for under section 176 and 177 shall apply for the non-filing of the thing and for incorrect information given. It doesn't require a presidential thing. You are only invoking the power of a central enactment to then I just mentioned the fact that Lokayukta is not a police officer. So I had requested the government to include the name of the position, Lokayukta, as a superior police officer under section 36 of the Criminal Procedure Code. That gives the Lokayukta to supervise the offences under the Prevention of Corruption Act. That is necessary. I mean, it could be misused by the Lokayukta, but that's a different matter. But it will be used for better, because very often we find the police officers in the Lokayukta, though they are independent of the main police force, they are all brought in on deputation from the parent organization. So naturally, their umbilical is still attached to that parent organization. And we all have our own opinion about that. So, after 3 years, a good officer does something, is taken away. I left Lokayukta. Just before that, they took my ADGP. They took a very senior officer, SP, was a very tough officer, who filed a charge sheet against Minister Katta Subramanian Naidu and his son. They have taken him away. Then a particular officer was invested with the power of investigating the charges against the former Chief Minister. He has been shunted out. No order, taking is there, this thing. But while sending the officers, if you are not a superior police officer, you cannot demand that give me that officer, give me this officer. So in Karnataka, I put when the relationship was good, we exchanged letters saying that when a police officer being, for that matter any officer, is being sent to the institution of Lokayukta, a panel of minimum 3 names shall be sent. And it will be then looked into by the Lokayukta from different angle. If it's not satisfied with any one of them, send the panel back and say, I want one more panel. And you choose the officer. Then while working so, you can always keep an eye on a doubtful officer. Otherwise that officer will ask me, who are you? You have nothing to do with me. I am doing under the Prevention of Corruption Act. You are not a police officer. I mean, these are small little things which goes a long way in keeping the institution clean. And that is a necessity, especially in these type of ombudsman bodies. Well, if from the beginning they had given a separate police force called the Lokayukta, which they come in, they remain there, they then retire, then they recruit somebody, then it would have been a different thing. Not that it will make anything for good, because when you find a bad officer, you can't send him back. You have to remove him, then Article 309 to 311 procedure will have to be followed. Yeah, then the next thing is about the contempt power of the Lokayukta. It is there in Karnataka Act also. I never used it, even though a lot of compliments were paid to me, which might have amounted to contempt. I never used to use that power because I have my own doubt about the legality of that power. There is a judgment of the Supreme Court which says only institutions which are capable of executing their own orders alone have the trapping of a court. It's not all institutions which will have the trapping of a court. Therefore, empowering the Lokayukta either to initiate suo motu contempt, either civil or criminal, according to me, may not stand the test of it. But since it has not been questioned, let it go on until the court says something. But we can make other alternate arrangements. For example, you can ask the registrar of the saying, without summoning the Lokayukta to file a criminal defamation or a civil defamation against the person's thing. That could be there. But since nobody has raised any objection till now, it is there in other enactments and all, let it remain. But I want to warn you that there is a difficulty in this. Frankly, there are very, very many, I don't want to highlight it, typos or grammatical errors in this, where if I must point out at least one to you. The reference therein to the High Court shall be constructed as including reference. It's not, it is to be construed as including, not constructed. Like that, there are many such errors are there. That can be, of course, the drafting section will look into it. And there are some suggestions somewhere in your proposals also that Lokayukta should be permitted to punish the erring officers. I think it's constitutionally not valid. The theory, which is well accepted, that you cannot be a judge, jury, and the executioner. You cannot receive a complaint, investigate a complaint, then prosecute it yourself, then you decide it yourself. Of course, unless it is an administrative misconduct. There again, if you want to impose a major punishment, like dismissal or other major punishment, then you will have to hold an independent inquiry, give an opportunity of being heard. Again, both the 2003 Act and the Law Commission proposal says, in the preliminary inquiry as well as the further inquiry, you should be given, the officer concerned should be given the right of being represented by a counsel, lawyer. Please don't do that. That will become another thing, the very object which you would have then incorporated, quick trial. According to the proposals, 1.5 years the trial should be over. That is the proposal even in Jan Lokpal. This is at 1 year. As many special courts as is required to be done should be at the same time, I think we should enlighten the government about bringing about certain changes in the Evidence Act and the procedural code in the criminal side, or even for that matter in the civil side, because today it's a well-known fact. No case, be it civil or criminal, comes to a final decision for less than 25 to 30 years. That is, I'm saying, the quickest case. Take the case of Sukram. 96, when he was a Minister for Telecommunication, they found few crores of rupees under his mattress. 96 itself, CBI filed a charge sheet. 96 to 2009 the trial went on. 2009 February he was sentenced to 3 years imprisonment. He was 83 years old then. High Court has stayed it, referred it to a division bench. I don't know, maybe then there may be a reason for it. Maybe the disposal is delayed there. Now thereafter there is a Supreme Court. Now in Supreme Court many things come up because I was also sitting there. By the time Sukram may be 90 years old. Ariyar, why do you want to send a 90-year-old man to jail? Imprisonment already undergone, uphold the conviction. And that's the human conduct. 10 years in the first court is an average thing today in any state, including in Karnataka. In that 10 years, you can get the witness, purchase the witness, threaten the witness, he may disappear. And the most important thing is, it is no more a deterrent. If you get a feeling that there is a possibility of my going to jail within 1 year, then it is a deterrent. Therefore, I think all states which are really concerned with quick justice delivery system should adopt a system or at least pressurize the government of India to change it. What is this? I can't understand. It is better to acquit 10 guilty people than one innocent man. What has it done? It has increased the number of criminals more in the society. I have not seen in my 42 years of career in the law this thing, not a single person being sent, innocent person being sent to jail. I remember my father, who was a judge himself, was saying, look, you can't fry everything in ghee. Things have changed. You got to use now dalda or some other thing and get going. You can't go on looking at it in everything in a microscopic thing. All right, benefit of doubt should go to the accused. I mean, there are very many doubting Thomases. You create a doubt. Take the case of Kasab. Some 600 witnesses were examined to show that what he did was he killed 7 people. Fortunately, the trial court and the high court did not believe in the doubts that was created. Some of the questions were, did he use the index finger to pull the trigger? Or did he use the other finger? Now out of 600 people, some will say index finger, some will say other finger, some will say we don't know. So there is a doubt. Benefit of doubt should go to him then. It is not the quantity of evidence that really matters, it is the quality of evidence. Therefore, 1 witness, 2 witness, 1 document, 2 document are more than enough if you have a right thinking judge presiding over the court. We've got to bring about these changes, but very, very unfortunately, let me tell you, with all respect to politicians and whoever is in power, the attempt is to dilute the possibility of a conviction.